Good morning. It's a beautiful June bank holiday Monday here in Gorry in Broadford in County Kildare where I live. And in this video I want to touch upon a subject that comes up often enough, and that's to do with the validity of deeds and how to sign or how to execute a deed in order to make it valid. Over the last number of years, especially since the downturn with the property crash in 2009 or 2010 thereabouts, a lot of people who had overborrowed, property developers and others who had overborrowed and had very little defence in terms of being able to pay back the money, and they obviously got into difficulty. Sometimes they would rely on technical defences. Now, I have seen a lot of cases, I've read of a lot of cases where technical defences were put forward and they were not successful. In this particular case, and today is June bank holiday weekend, in the last few weeks there, or certainly in the last few months, there was a Supreme Court decision in relation to a case involving Ulster Bank. And the borrowers put forward an argument that the appointment of a receiver to their property was invalid and unenforceable as a consequence. And the reason for that is because section, I think it's 64 of the Land and Conveyancing Law Reform Act of 2009 stipulates and carries on the whole question of the execution or signing of deeds. The bottom line is this: an individual can sign a deed, but a company must affix the company seal to the deed in order for it to be valid. So, in this particular case, the borrowers to whom a receiver had been appointed, or certainly the property of theirs, a receiver had been appointed by the Ulster Bank, and there was no seal, no company seal affixed on the deed of appointment of the receiver. And they argued, therefore, that the appointment of the receiver was invalid and wasn't in accordance with the Land and Conveyancing Law Reform Act of 2009. The Supreme Court looked at the case closely and they decided as follows. The deed was signed, the deed of appointment of the receiver was signed by a bank official, by an Ulster Bank official. And that Ulster Bank official simply signed his name. But the Supreme Court found that because he was signing as an individual under a power of attorney granted by Ulster Bank to him, then it wasn't necessary for the seal to be affixed to the deed of appointment of receiver. Because even though the deed was between the parties, it could be created or executed or signed by somebody else, not necessarily the company, not necessarily the Ulster Bank, but by an Ulster Bank official. And Ulster Bank had granted a deed, or a grant of power of attorney rather, to that official. And that official then signed the deed of appointment of receiver to the property of the borrowers. And the bottom line is that the Supreme Court held that because the bank official was signing as an individual, even though he was doing so on behalf of the bank, there was no need for a company seal. All that was required was the signature of the bank official. That was witnessed, and therefore the appointment of the receiver to the property in question was valid according to the Supreme Court. If you go to my website, businessandlegal.ie, you'll get a blog post on that particular case, and there's a link in the blog post as well to the particular decision, the full decision of the Supreme Court. It's worth having a look at, but if you're ever confused, or if you ever think that you might have a technical defence or technical argument in relation to the execution or signing of a deed, and this would apply to a mortgage, it would apply to a conveyance, it would apply to an assignment, it would apply to a lease, It would apply to many, many legal documents which are intended to be deeds. And in the ordinary course, an individual must sign, or a company must apply the company seal. But in this case, as I say, the technical defence failed. It's a decision that's worth looking at, just to be clear in your own mind what's required and what's not required. And it's another example, quite frankly, of a technical defence that was unsuccessful in the Supreme Court. Go to my website. I'll put a link underneath this video, and a link to the blog post, but you can link from the blog post then to a full decision of the Supreme Court and have a look at it more closely. I hope you find this video useful. If you do, you might give it a thumbs up down below, and thank you for supporting my YouTube channel, for the comments, the shares, the likes, and so on.